By the time Judge Richard J. Leon was asked to stop Donald Trump's White House ballroom, the East Wing was already gone. Not damaged, not under review. Gone, reduced to rubble, rebar, and a construction crane rising against the south lawn sky. The lawsuit came 6 weeks later. The injunction came 5 months after that. And the question Leon was ultimately forced to answer had never, in the history of the United States, been formally put to a federal court. Can a sitting president tear down part of the White House, rebuild it with private donor money, and never once ask Congress for permission? By March 31, 2026, Leon had his answer, and it landed like a gavel on 200 years of precedent. Here's what makes this more than a construction dispute. The most surprising part of Leon's ruling isn't that he said no. It's what he had to go through to get there. Stick with this, because the path to that ruling tells you everything about how close the whole thing came to slipping through untouched. All right, let's start with what actually happened on the ground. On July 31, 2025, the White House announced plans for a new state ballroom. Roughly 90,000 square feet. Private funding. Architect, McCreary Architects. Contractor, Clark Construction. The East Room, the White House's largest ceremonial space, seats 200 people. The new ballroom would seat 650. Trump later claimed 999 at a donor dinner. The price tag started at $200 million and, by the time the courts got involved, had reached $400 million. Double the original number. The project was growing in ambition as scrutiny increased, which is not how government projects typically behave under legal challenge. Then, on October 20, 2025, Trump posted that ground had been broken. The next day, photographs showed heavy excavators tearing into the East Wing structure. Within days, according to Leon's own February opinion, the entire East Wing was gone. A wing built in 1902 expanded in the 1940s, approximately 15,000 square feet, demolished. The building being replaced was 1/6 the size of the one being built. The National Trust for Historic Preservation sent a letter urging a pause on October 21st. The machinery didn't stop. Think about that image. One of the most photographed buildings on Earth, with a gap where a wing used to be. An open wound, deliberate and fast. The lawsuit came December 12th, and here's where the story gets more complicated than the headlines suggest. When the National Trust filed for an emergency restraining order, Leon denied it. Not because he was sympathetic to the administration, because the legal standard for emergency relief requires showing imminent, irreparable harm, and the government had made representations in court. No above-grade construction before April 2026, and consultations with planning bodies would proceed. Leon took those representations seriously, but he added something the administration should have remembered. If below-grade work locked in the ballroom's scale before the merits were decided, the government, in Leon's words, should be prepared to take it down, depending on the outcome. Construction continued. In February 2026, Leon denied a preliminary injunction again. Most coverage got this wrong. It was not a win for the White House. Leon's February opinion identified a technical problem. The plaintiffs had sued under the Administrative Procedure Act, targeting a White House office that was likely not an agency under that law. The administration had deliberately routed the project through the Office of the Executive Residence precisely to insulate it from standard legal challenges. Plaintiffs' attorneys called it a Rube Goldberg machine, a deliberately overcomplicated workaround engineered to avoid the simplest answer, which was to go to Congress. But here's what Leon did. He wrote a roadmap inside his denial. He told the plaintiffs exactly which legal theory they needed. An ultra-vires claim, a direct argument that the president simply lacked statutory authority for this action, regardless of which office managed it. He said if the complaint were properly amended, the court would expeditiously consider it. He called the underlying issues novel and weighty. This was not a judge brushing the case aside. This was a judge clearing the lane. 4 days after Leon's February opinion, the National Trust filed a second amended complaint with the ultra vires claims. 6 weeks later, Leon ruled. If you're finding this useful, hit subscribe. I drop videos like this every week, and the ruling itself is where this whole thing lands. Okay, remember how I said the most surprising part was still coming? Here it is. On March 31, 2026, Leon granted the preliminary injunction. Construction halted. And the language he used was not the careful, hedged prose of a judge trying to minimize his footprint. He wrote, "No statute comes close to giving the president the authority he claims to have." He wrote that the project must stop until Congress authorizes its completion. He drew the distinction that cuts to the bone of the entire dispute. Trump is the steward, not the owner of the White House. Then came the line with the exclamation point, rare in federal judicial opinions. This clearly is not how Congress and former presidents have managed the White House for centuries, and this court will not be the first to hold that Congress has ceded its powers in such a significant fashion. When a federal judge puts an exclamation mark in a ruling, he means it. Let that sit for a second. A judge appointed by George W. Bush, not a partisan actor, looked at a $400 million construction project funded by private donors, routed through a White House office specifically chosen to dodge standard legal review, and said, "Not one statute in American law supports this. Every president before you knew they were a steward of this building. That understanding is not optional, it is legally enforced." And yet, the East Wing is still gone. That's what Leon's ruling can't undo. He drew a legal line in March. The original structure fell in October. 5 months elapsed between demolition and injunction. 5 months in which Congress held no emergency session. The Commission of Fine Arts approved the project with, quote, "enthusiastic support," and the National Capital Planning Commission hadn't even voted yet when Leon ruled, 1 day before its scheduled April 2nd action. The oversight system was still running when the court said stop. So the White House now sits with a 15,000 square foot gap in its historic composition, a halted construction crane, and a legal fight that may reach an appellate court, and possibly a Supreme Court reshaped by the same presidency whose ballroom is at stake. Leon delayed enforcement 14 days for appeal. The final word hasn't been written. What Leon gave us is this: a definition of the outer boundary of presidential power over the building where that power lives. He said the president is a tenant of history, not its owner. He said Congress must authorize this. He said it clearly, on the record, in writing. Whether that answer holds, whether the institutions that were supposed to check this power checked it in time to matter, is a question the rubble of the East Wing answers differently than the ruling does. The law said no. The building is still gone. Both things are true. If this story made you think, share it with someone who needs to hear it, and subscribe so you don't miss the next one. The appeal is coming, and when it does, we'll be here.